Good morning. I hereby call to order this 13th meeting of the Pennsylvania Public Utility Commission for the year 2018, and I ask that you please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Before we start, let me give my usual announcement that we ask everyone to take notice of the emergency procedures that are on the inside of the agenda if we need to evacuate this room, or for your comfort levels if you need to find where the restrooms are as well. The first matter on this morning's agenda is the approval of the minutes for August 2nd, 2018, and I recognize Commissioner Coleman, who is the editor.
Thank you, Madam Chairman. I've reviewed the minutes of the August 2nd, 2018 public meeting, and I move they be approved as submitted.
You have heard the motion of Commissioner Coleman. Is there a second?
Second.
You heard the joint motion, joint seconds, Commissioner Kennard and Commissioner Sweet. Is there any further discussion or edits of those minutes? Hearing none, all those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. We will move on to our agenda for today and call up our Secretary Chiavetta, who will lead us through the agenda.
Good morning, Madam Chairman. Good morning, Commissioners.
Good morning.
Your various bureaus and offices offer the following agenda items for your consideration. Let us begin on page 1 of the regular agenda. Regarding matters presented by Director Gramola and the Bureau of Administration, in an omnibus motion, it is recommended that the Commission adopt all of the items on page 1, beginning with the selection of a vendor for the PUC's website design, and continuing on page 2 to include all of the items on page 2, ending with the approval of supplemental fees upon electric and natural gas suppliers.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
Aye. Aye.
Any opposed? The motion passes 5-0.
Turning to page 3 in matters presented by Director Monahan and the Bureau of Audits, it is recommended that the Commission adopt in an omnibus motion the first 2 items regarding the transmission charges of PECO Energy.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Kennard. Is there any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
It is recommended that the Commission adopt the MEI report and implementation plan of the Philadelphia Gas Works.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Kennard. Any discussion?
I have a statement, Madam Chair.
Commissioner Sweet.
Before the Commission today is the Management Efficiency Investigation of Philadelphia Gas Works. The scope of this investigation was confined to an examination of the company's progress in implementing 65 of the 76 original recommendations from the Management and Operations Audit released in October of 2015. While I commend PGW for effectively and substantially implementing 28 of the 65 prior recommendations, and for acting on most of the remaining recommendations prepared by the Commission's Bureau of Audits, my comments today involve a specific recommendation and subsequent follow-up finding within PGW's MEI regarding the company's duplicative governance structure and its associated expenses averaging $954,000 a year through the years of 2016 and 2017. Since 1972, PGW has been governed by 2 city entities, the Philadelphia Facilities Management Corporation, PFMC, and the Philadelphia Gas Commission, PGC. At its inception, both organizations were tasked with separate responsibilities. PFMC functioned much like a traditional board of directors, while the PGC's responsibilities included rate making and adjudicating of consumer complaints within PGW's service territory. However, when the PUC assumed jurisdiction over PGW in 2000, the PGC's, the gas commission's, role evolved to focusing on approving budgets, gas contracts, and real estate acquisitions, all functions both previously and currently also assigned to the PFMC. As I mentioned earlier, these redundancies not only create a layer of administrative confusion, it comes at a cost of nearly $1 million, and it's cost borne by PGW's ratepayers. The Commission's Bureau of Audits has recommended that PGW streamline its governance structure ever since rate-making authority fell under the Commission's jurisdiction, and that, as I said, was 2000. In the company's most recent 2015 management and operations audit and follow-up efficiency investigation, it was noted that, quote, without the necessary changes to PGW's governance structure, the company will continue to be constrained by a duplicative and unclear governance structure that falls short of meeting standard governance practices. Despite numerous recommendations by our audit staff, PGW's overlapping governance structure has remained unchanged. In its 2015 management audit response, the company cited that governance changes are beyond the capacity of executive management, and that is true. They noted that any changes to its current structure would require an amendment to the City of Philadelphia's ordinance, an action which must be taken by City Council and affirmed by the mayor. Therefore, I urge the City of Philadelphia's government to seriously evaluate PGW's governance structure and to create the changes needed to reduce the financial impact that the current duplicative structure has on the city's ratepayers. Thank you.
Thank you, Commissioner Sweet. Any further discussion?
Madam Chairman, first I want to thank the Bureau of Audits for their diligence, as always, in this management efficiency investigation and the manner in which they consistently stay on our companies and find improvements. And I want to associate myself secondarily with the comments of Commissioner Sweet. This is not the first time this has been pointed out. There have been multiple occasions over the past 15 years where we've made this suggestion, and I fully support our continued consistent encouragement that the inefficiencies in the management of this company undertaken by the city be removed, because there will be, as Commissioner Sweet notes, substantial savings to customers and taxpayers of the city of Philadelphia.
Thank you, Commissioner Kennard. Any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
At the bottom of page 3, it is recommended that the Commission release the audit report of the Pennsylvania Electric Company.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second?
Motion by Commissioner Sweet, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 4 and matters presented by Director Sophie and the Office of Special Assistance. It is recommended that the Commission adopt the proposed opinion and order regarding the complaints of SBG Management versus the Philadelphia Gas Works.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Sweet. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
It is recommended that the Commission adopt the proposed opinion and order in the complaint of Marlene Broman versus the West Penn Power Company.
Is there a motion to call up the matter for consideration?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Coleman. Any discussion?
Madam Chair, I have a motion.
Commissioner Sweet.
I ask that my motion be placed upon the record as though I'd read it in its entirety. This matter comes to us by exceptions filed by both the complainant, Marlene Broman, and the respondent, West Penn Power Company, to the initial decision of Administrative Law Judge Jeffrey Watson. The ID, number one, dismissed Ms. Broman's objection to the removal of certain trees from the right-of-way across her property based on a finding that a prior complaint had already addressed this issue. Two, sustained her allegation that West Penn had failed to provide reasonable and adequate service. And three, imposed a civil penalty. In his analysis, ALJ Watson held that West Penn Power had failed to provide reasonable service in managing only 100 feet of the 180-foot right-of-way, and by failing to communicate the effect of that this decision had on the vegetation management to be performed, the method in which it was communicated with Ms. Broman, and for failure to provide a reasonable explanation and authority for these determinations. In fact, the witness produced at the hearing could not answer questions regarding the commission-approved vegetation management plan because he did not use it. This was consistent with Ms. Broman's own testimony that the West Penn Power representative sent to discuss vegetation management with her was not aware of the vegetation management plan. The information given to Ms. Broman could have supported at least three different results. The ALJ's analysis was based on his own reading of the facts, and it is appropriate that we rely on his evaluation. This violation was a new instance of unreasonable and inadequate service, which occurred following the completion of the prior complaint case, and was therefore not dismissed under res judicata. The Commission has long been an advocate for vegetation management that will ensure the safe and reliable electric service, in the Commonwealth, and has instituted policies to support such service. The VMP requirement is one such policy, and electric distribution companies are required to develop the plans and update them every few years and to use them. The other side of this policy, however, is the expectation that the utility will treat the property owners fairly by letting them know exactly what to expect in the case of right-of-way maintenance. This simply was not done here. The ID contains an analysis which results in a civil penalty of $5,000, which is eliminated in this motion in order to reflect the severity of the violation. Accordingly, I move to deny the exceptions of both West Penn Power and Ms. Broman and to adopt the initial decision of ALJ Watson as modified by this motion. Therefore, I move that the exceptions filed by West Penn Power are granted in part and denied in part, that the exceptions filed by Marlene Broman are granted in part and denied in part, that the initial decision of Administrative Law Judge Jeffrey Watson is modified consistent with this motion, and that the Office of Special Assistance prepare an appropriate order consistent with this motion. Thank you.
You have heard the motion of Commissioner Sweet. Is there a second?
Second.
Second by Vice Chairman Place. Any discussion?
Madam Chairman, I have a statement on this matter.
Commissioner Coleman.
Thank you. I'd ask that my statement be entered into the record as though I read it in its entirety. The case before us involves an ongoing dispute about West Penn Power Company's vegetation management program and a right-of-way across the complainant's private property. West Penn obtained an easement there in 1968 to the site and constructed the electric transmission line. This transmission line is subject to mandatory FERC reliability requirements, which includes the development and implementation of a vegetation management plan along the length of the interstate electric transmission system. In 2012, West Penn met with and notified the complainant of its plan to undertake vegetation management within the right-of-way. The complainant objected to aspects of the plan and filed a formal complaint in 2013. She requested, among other things, that West Penn be stopped from removing 11 trees located within the right-of-way. In the order entered in April of 2014, the Commission concluded that West Penn Power's approach was reasonable and dismissed the formal complaint. However, the complaint did not accept the Commission's decision and did not allow the trees at issue to be removed. In May of 2015, after an in-person visit by West Penn personnel to the property to discuss the matter in which the complainant filed this complaint and again asked that the Commission to prevent the removal of the trees at the center of the dispute. Early in the proceeding, West Penn asked that the complaint be dismissed as it involved the same parties, the same issues decided in the 2014 order. The presiding ALJ denied this motion and the case proceeded to an evidentiary hearing. During the 2016 evidentiary hearing, the complainant testified as to her ongoing objection to West Penn's vegetation management plan. The only new fact that was introduced involved a brochure that was given to the complainant at the conclusion of the first complaint, but before the filing of the second complaint. I believe the brochure can be fairly described as a consumer education document for the purpose of which is explained at a very high level, in general terms, the First Energy vegetation management practices across many rights-of-way it manages in Pennsylvania and other states in the territories of its operating companies, including West Penn. Near the end of the hearing, West Penn called Mr. Weston, an expert in forestry, to testify to the work that remained to be done as part of the same plan, developed in 2012. Mr. Weston had visited the property in 2012 and assessed the needed work. He is a certified arborist, and his duties included identifying trees that may be incompatible with reliable transmission service and the appropriate remedial action. While he was on the stand, the presiding ALJ questioned him about the alleged discrepancy between the brochure and the vegetation management plan of the property in question. The ALJ was disappointed with the responses, and that based upon the testimony, the ALJ held that West Penn provided unreasonable service and that a civil penalty of $5,000 should be imposed. In its exceptions, West Penn reiterated its request that the entire complaint be dismissed under res judicata, and that and that in the alternative, the commission find that they provided reasonable service to the complainant. I agree that this complainant should have been dismissed and believe that it should have been done in 2015. I'm satisfied, based upon the complainant's own testimony, that the relevant material issues are identical to those identified in the 2013 complaint. The complainant has known since 2012 which trees West Penn intended to remove, and that the relief she is seeking is the same that was in the prior proceeding. Additionally, I don't believe that the complainant has met her burden of proof in demonstrating that the design, distribution, and communication regarding the vegetation management brochure rises to the level of unreasonable service. While it is unfortunate that Mr. Weston, the arborist, was unable to reconcile that to the ALJ's satisfaction, the brochure and the plan, it's important to remember the function that he performs and his reason that he was called to testify. I find it commendable that for an electric distribution company to develop and distribute these consumer education brochures to property owners. I agree with West Penn that they're only intended to describe company practices in a general way, and that what controls are the terms and conditions of the easement, and that the vegetation management plan on file with the commission for the specific property. There is no statute or commission regulation that requires West Penn to provide these materials, and at present, no commission rule or guideline govern these formats or the content. As with any consumer education materials, I would encourage West Penn to review and revise these materials periodically based upon experience and customer feedback. Accordingly, I will be dissenting, as I believe the complaint should be dismissed in its entirety. Thank you.
Thank you, Commissioner Coleman. Any further discussion?
I'd like to associate myself, Madam Chairman, with the statement of Commissioner Coleman.
Thank you, Commissioner Kennard. Any further discussion? Hearing none. On the motion, all those in favor say aye.
Aye.
Any opposed?
No?
No.
Opposed?
The motion passes 3-2, noting the dissent of Commissioner Coleman and Commissioner Kennard. On the matter as amended by the motion, if there's any objection, we'll take the previous roll call. Seeing no objection, the matter as amended passes 3-2, noting the dissent of Commissioner Coleman and Commissioner Kennard.
Turning to page 5, it is recommended that the commission adopt the proposed opinion and order regarding the joint petitions of Keystone Cab et al.
Is there a motion to adopt the staff recommendation?
So moved?
Is there a second?
Second?
Motion by Commissioner Kennard, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
It is recommended that the commission adopt the proposed opinion and order in the complaint of Robert Matu versus the West Penn Power Company.
Is there a motion to call up the matter for consideration?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Sweet. Any discussion?
I have a motion, Madam Chair.
Commissioner Sweet.
Actually, it's a joint motion with Vice Chairman Place.
Commissioner Sweet.
Thank you. I ask that our motion be placed upon the record as if I'd read it in its entirety. Again, the theme of the day, vegetation plans and certain utilities. Before the Commission today is a petition for reconsideration filed by West Penn Power Company in the formal complaint filed by Robert Mathieu, alleging that the vegetation management plan planned by West Penn Power, WPP, for the transmission right-of-way that crosses Mr. Mathieu's property is unreasonable. The right-of-way is approximately 25 yards from Mr. Mathieu's home, gardens, fish pond, and 2 shallow wells that serve his house, and Mr. Mathieu objects to the use of herbicides on the right-of-way. The Commission found that because of the general nature of the vegetation plan filed by West Penn Power, the proposed use of herbicides was consistent with the filed plan, but was not reasonable under the specific circumstances here. We stated that the nature of the case was more like a petition for relief than a formal complaint, and exercised our ability to treat it as such, noting the action did not change the burden of proof or prejudice the parties in any way. West Penn Power filed a petition for reconsideration, listing 5 reasons, 4 of which we dismiss here, and the 5th dismissed in part. What is left is the claim that West Penn Power's due process rights are violated by the Commission's treatment of the formal complaint as a petition for relief after the close of the record. Please note that we would have preferred that the utility see this as an opportunity to open a dialogue with the customer and create goodwill rather than acrimony, as this would be consistent with the Commission's traditional view of, quote, service, unquote. Contrary to West Penn's allegations, we do not supersede the rules and regulations governing service complaints, which are well established and designed to address most interactions between a utility and its customers. Rates, terms, and conditions of service remain subject to tariffs and existing law. There is no mention of evaluating unique individual needs of customers. Rather, West Penn, with the support of the other EDCs, has indicated by letters of support of the petition for reconsideration filed by the Energy Association and PP Electric, it makes clear that the traditional complaint route is somehow preferred. If we agreed that there is a due process violation in labeling the procedure as a petition for relief, if we were to agree to that, the remedy would be to remand the matter to allow the parties to present any additional evidence and legal argument related to petitions for relief. While we do not agree that relabeling resulted in a due process violation, in the interest of judicial efficiency, we will take advantage of the opportunity that the petition for reconsideration presents to return to the original form filed at this docket, and we treat the matter as a formal complaint. Accordingly, the petition for reconsideration is granted. In our original order, we found that WPP's proposed plan was consistent with its filed vegetation management plan and that there was no violation. However, in now reconsidering the matter, we find that a specific proposed plan for vegetation management of a right-of-way that crosses a customer's property can be consistent with a filed vegetation management plan, but nonetheless still be unreasonable. In fact, we note that on page 11 of the July 17th order, we stated, quote, given this unique fact pattern, the use of herbicides would be unreasonable, close quote. We find today that the plan for clearing Mr. Mathieu's land is unreasonable and is a violation of Section 1501. Therefore, we move, number 1, that the petition for reconsideration filed by West Penn Power is granted consistent with this motion. 2, that the Commission's order of July 17, 2017, entered August 14, 2017, is revised to find that the complaint filed by Mr. Mathieu is sustained. 3, that West Penn Power is prohibited from using herbicides on the right-of-way that crosses the real property of Robert M. Mathieu. And 4, that the Office of Special Assistance prepare an appropriate order consistent with this motion. Thank you.
You have heard the joint motion of Vice Chairman Place and Commissioner Sweet as read by Commissioner Sweet. Is there a second to the joint motion? I will second the motion. Under discussion, is there any discussion?
Madam Chairman, I have a joint statement.
Commissioner Coleman.
Thank you. I have a joint statement with Commissioner Kennard. I'd ask that the joint statement be entered into the record as though we had read it in its entirety. Before the Commission is the West Penn Power Company's petition for reconsideration of our opinion in order of July 14, 2017. West Penn requests that the Commission grant reconsideration, rescind our prior order, and adopt the initial decision of the Administrative Law Judge Dunderdale. We agree with the entirety of the West Penn's request and therefore are dissenting from the proposed joint motion. Initially, we find that West Penn has met the Duke standard for reconsideration, as it did identify several considerations that were overlooked or not addressed in the July 14, 2017 order. This includes, but is not limited to, the failure of the prior order to address relevant Commission and Pennsylvania Commonwealth Court case precedents that should lead to a different result. The joint motion proposes to grant reconsideration and now concludes that West Penn proposed use of herbicides was unreasonable and therefore is now a violation of 1501 of the Public Utility Code. The joint motion would permanently bar the use of all herbicides on the complainant's property by West Penn Power. The joint motion further maintains that it was appropriate to treat the complaint as a petition for relief and denies that there were any prejudice to West Penn and by implication of any violation of their rights of due process by applying this new standard after the close of the record. The joint motion insists that the holding of the prior order is limited and only applicable to the facts in this case. We cannot conclude, as stated in the prior dissent, that the complaint has met its burden of proof and there was a violation of 1501 of the Public Utility Code. In the underlying complaint, Mr. Matu objected to West Penn's use of herbicides to prevent the regrowth of trees in the right-of-way of the transmission line. Mr. Matu explained that he believed, based solely on his personal opinion, that the use of herbicides was unsafe given the proximity of the fish pond and the wells on his property. However, asserts the personal opinion and perceptions that don't constitute facts of evidence. Moreover, the complainant was not qualified as an expert witness and called no witness to support his position. In contrast, West Penn provided the testimony of 3 witnesses, 2 of which were qualified as experts in the field of herbicide application, action, environmental impact, and safety. These witnesses testified that the proposed method of vegetation management for the property was reasonable, safe, lawful, and consistent with the industry best practices. Specifically, West Penn proposed to directly treat the stumps of trees that it had cut with the herbicide to prevent regrowth. West Penn's experts explained that the herbicide would be applied by trained personnel and that the product would not travel beyond the root system of the trees. Their testimony was persuasive that the method of vegetation management was less disruptive to the ecosystem and more cost-effective than the repeated pruning of the same trees, which had the propensity for rapid growth. Although the joint motion finds that West Penn's proposed plan for this property was in violation of 1501, it fails to explain exactly how the plan was unreasonable and why the testimony of non-expert laymen outweigh the testimony of multiple expert witnesses. It simply states that the risk of herbicides entering the complainant's drinking water was, quote, too great to permit, end quote. Neither the complainant nor the joint motion identify any specific defects or concerns regarding the training of West Penn personnel, the method of application, or the choice of herbicides used. Based upon the lack of such details, we do not believe that the joint motion satisfies Section 703E of the Public Utility Code, which requires that the Commission make detailed findings in its disposition of complaints. We do not agree with the assertion that this is limited by narrow holding. The complainant offered only his expert opinion that the use of herbicide should be prohibited on the property, given that he received his water from 2 wells located approximately 70 feet from the transmission line right-of-way. There are many property owners in Pennsylvania who receive their water from wells. It is reasonable to assume that many of these properties are also crossed by electric transmission or distribution lines or even aerial facilities of telecommunication utilities. We believe that other property owners will be able to cite this case for reliance on the holding, and at a minimum, herbicide should not be used to manage utility rights-of-ways that are within 70 feet of private water supplies. However, it is unclear what the minimum safe distance the Commission deems to be appropriate before herbicides can be used, and upon what evidence this requirement is founded, given the Commission's rejection of multiple expert testimony in this case. The safety of public's drinking water is, of course, very important and is accordingly subject to strong regulation both at the federal and state level. While the Commission does regulate the provisions of water service by public utilities, it is not the lead agency to ensure the safety of drinking water, including the providing through wells and the protection of the environment. We're unaware of any legal prohibition on the use of herbicides as proposed by West Penn. Neither the complaint nor the joint motion identifies any such restrictions. As stated in the prior dissent, the Commission does have extensive regulations governing the safety and reliability of electric utility service. In its enactment of the Competition Act, the Pennsylvania General Assembly explained a preference that electric reliability standards be addressed through regulation and that it not be in conformity with established industry standards. Should the Commission deem it appropriate to develop rules for the use of herbicides by public utilities, we believe we must do this through a rulemaking proceeding as opposed to customer complaint proceedings. We do wish to reiterate our consideration of the concern raised by the complainant here. However, our decision must be based upon the evidentiary record. Here, the substantial, credible record evidence shows that West Penn Power's transmission vegetation management program, including the use of herbicides, is reasonable. Proper vegetation management within transmission line rights-of-way is critical to ensuring that our electric grid operates in a safe and reliable manner. We observed that both the Energy Association of Pennsylvania and PPL Electric Utility Corporation took the very unusual step of filing letters in support of West Penn's petition, noting their serious concern regarding the holding at issue and its effect on the provisions of public utility service. Accordingly, because we find that the joint motion is not based on substantial evidence, appears to be in conflict with applicable law, and violates West Penn's rights to due process, we must dissent. Thank you.
Thank you, Commissioner Coleman. Any further discussion?
Yes, I also have a statement on the matter.
Vice Chairman Place.
Thank you. I've joined the motion of Commissioner Sweet, as I believe that Mr. Matou has valid concerns regarding West Penn Power's planned vegetation management, specifically the use of herbicides in close proximity to his wells, his sole source of drinking water. In addition, I want to emphasize that the company should have amicably, reversing consonants, settled the matter to address Mr. Matou's concerns and proposed and employed alternate methods that would effectively manage the vegetation near the sources of drinking water while ensuring safe and reliable service. All parties would have been better served by negotiations and modifications regarding vegetation management in this case, rather than the process pursued herein. Thank you.
Any further discussion on the joint motion? Hearing none. On the motion, all those in favor say aye.
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 Any opposed?
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 The motion passes 3-2, noting the dissent of Commissioner Coleman and Commissioner Kennard. On the matter as amended, if there's no objection, take the previous roll call. Seeing no objection, the matter as amended passes 3-2, noting the dissent of Commissioner Coleman and Commissioner Kennard.
Turning to page 6, it is recommended that the Commission, in an omnibus motion, adopt the first two items at the top of page 6.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
It is recommended that the Commission adopt the proposed opinion and order regarding the complaint of West Goshen Township versus Sunoco Pipeline LP.
Is there a motion to call up the matter for consideration?
So moved.
Is there a second?
Second.
Motion by Commissioner Sweet, second by Commissioner Kennard. Any discussion?
Madam Chair, I have a motion.
Commissioner Sweet.
Thank you, and this motion is short, and so I will just read it in its entirety. The case comes to us in a unique procedural stance where Administrative Law Judge Elizabeth Barnes excuse me, issued a recommended decision, an RD, and both parties agree with it, but filed a joint petition for settlement in lieu of exceptions. Anyway, the sole term of the parties' joint petition is that the commission adopt the RD without modification. In support of this unusual action, which is not supported by the commission's procedural rules, the joint petition cites to a prior commission order which approved a settlement filed in lieu of exceptions as precedent. However, in that case, the parties agreed upon substantive terms which differed from those in the initial decision, meaning that there would have been exceptions if the parties had not reached the agreement. In this situation, the commission evaluation of this settlement, or in that situation, excuse me, commission evaluation of the settlement was indeed necessary. Here, the joint petition for settlement is essentially an agreement to refrain from, one, filing exceptions, two, seeking reconsideration of or other relief contained in 52 PA Code 5.572, and or three, seeking review from a court of competent jurisdiction. Parties do not need commission approval to refrain from taking actions. The joint petition makes no substantive or procedural change to the RD or to the proceeding itself. If the parties had entered into an agreement prior to the service of the RD, which agreed to dispose of the substantive issues raised in the proceeding, then that agreement would have been evaluated by the ALJ, and the subsequent RD would have considered all the substantive terms. In this case, the parties waited until the ALJ had finished her evaluation of the record and applicable law, and then merely agreed with it. That is not a settlement. It's a decision by both parties to stop contesting the matter further in the subject docket. The parties are free to enter into such an agreement, and they could have simply notified the commission in a letter that there will be no exceptions or replies filed. In fact, they did not need to file anything at all. The settlement agreement before us does not raise any issues that require commission action. Accordingly, the joint petition is simply moot. I note that there is no opposition to the RD in this case and move that the commission adopt, the recommended decision in full without modification. Therefore, I move that the recommended decision of ALJ Elizabeth Barnes in the case captioned West Goshen Township versus Sunoco Pipeline LLC at docket number C-2017-2589346 served on July 19, 2018, is adopted without modification. That the parties shall comply with the directives in the recommended decision is adopted without modification, and that the Office of Special Assistance prepare an appropriate order consistent with that motion. Thank you.
You have heard the motion of Commissioner Sweet. Is there a second?
Second?
Second by Vice Chairman Place. Any discussion on the motion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. On the matter as amended, if there's no objection, we'll take the previous roll call. Seeing none, the matter as amended passes 5-0.
Turning to page 7, it is recommended that the commission adopt the proposed opinion and order in the complaint of Raymond Kokas versus Duquesne Light.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second?
Motion by Commissioner Kennard, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
It is recommended that the commission adopt the proposed opinion and order in the complaint of Robert Kuhn versus the Duquesne Light Company.
Is there a motion to call up the matter for consideration?
So moved.
Is there a second?
Second?
Motion by Commissioner Kennard, second by Commissioner Coleman. Any discussion?
I have a motion, Madam Chair.
Commissioner Sweet.
And I will read the motion in its entirety because it's relatively short. Before the commissioner exceptions of both Duquesne Light Company, DLC, and complainant Robert G. Kuhn Jr. to the initial decision ID of Administrative Law Judge David Salapa, ALJ, which grants the preliminary objections of DLC and dismisses the formal complaint. Mr. Kuhn's exceptions raise several issues. One, the reasonableness of the DLC plan to remove certain trees. Two, the request for an environmental assessment. And 3, the proper width of the DLC right-of-way in light of Commission Order in A-110150F0033. Duquesne's filing in that case indicated that the voltage would be increased on the line in question, but that the existing rights-of-way widths would, quote, remain unchanged, close quote. DLC's exceptions argued the Commission has no jurisdiction over this dispute, which it characterizes as a, quote, purely private dispute regarding property rights, close quote. DLC argues that this is a challenge to the scope and validity of the right-of-way agreement, which the Commission lacks jurisdiction to resolve. While there are matters raised that are outside the Commission's jurisdiction, there remains the allegation that DLC's proposed vegetation management plan for its transmission circuit is unreasonable, which is clearly jurisdictional. Accordingly, this matter is remanded to the ALJ for a determination of the safety impact of the proposed tree removal in the complainant's property, including but not limited to any erosion to the soil and sedimentation of the complainant's property, and any safety hazards resulting therefrom that may be reasonably identified, and the steps the DLC proposes to implement in order to adhere to its statutory duty to furnish adequate, safe, and reasonable service. In addition, DLC is directed to provide evidence regarding its actions pursuant to the 2007 LON order, including an accounting of the actions that it has taken and whether those actions are consistent with the original filing, whether the width of the right-of-ways have changed to support the increased voltage on the line, what communications with owners of underlying property has occurred, and any other relevant information aimed at determining whether the information the Commission relied on in granting the LON was in fact accurate. Accordingly, the ID shall be affirmed in part and reversed in part, and the case remanded to the Office of Administrative Law Judge for further proceedings consistent with this motion.
You have heard the,
No, I haven't moved yet.
sorry.
I know I said it was short, and that could be an
Did say it was.
item, I'm sure, of controversy and difference of opinion. Anyway, let me move that, number one, the exceptions of Robert G. Kuhn Jr. filed in this complaint are granted consistent with the motion. 2, that the reply exceptions of Duquesne Light Company are granted in part and denied in part consistent with the motion. 3, that the initial decision of the administrative law judge issued September 7, 2017 is affirmed in part and reversed in part, consistent with this opinion and order. 4, that this matter is remanded to the Office of Administrative Law Judge for further proceedings limited to the vegetation management claims appearing in the pleadings and the issues raised regarding whether the actions of Duquesne Light Company are consistent with the allegations and directives in the case docketed at A-110150F0033, the order of which was entered August 13th, 2007. 5, that the Office of Special Assistance prepared appropriate order consistent with this motion. And, Madam Chair, I'm completed. And in the future, I will more carefully edit these motions so I don't mislead you into thinking that I'm finished when I say I move. I apologize. No, I apologize to you. Thank you.
You have heard the motion of Commissioner Sweet. Is there a second?
Second.
Second by Vice Chairman Place. Any discussion on the motion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0. On the matter as amended, if there's no objection, we'll take the previous roll call. Seeing no objection, the matter as amended passes 5-0.
Beginning at the bottom of page 7, it is recommended in an omnibus motion that the Commission adopt the application of the York Water Company and continuing on page 8 to include all of the items on page 8, all of the items on page 9, all of the items on page 10, and all of the items on page 11, ending with the complaint of the Bureau of Investigation and Enforcement versus Pat's Excavating.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Sweet. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
Turning to page 12, it is recommended in an omnibus motion that the commission adopt both items on page 12.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Sweet, second by Commissioner Kennard. Under discussion, let me just state, for both items, I will be recusing myself from this matter because my brother is employed by Frontier Communications. Any further discussion on these two items? Hearing none, all those in favor say aye.
Aye.
Any opposed? The matter passes 4-0, noting my recusal on both.
Turning to page 13 in matters presented by Director Diskin and the Bureau of Technical Utility Services, it is recommended in an omnibus motion that the commission adopt all of the items on page 13, beginning with the application of the Mid-Atlantic Interstate Transmission, and continuing on page 14 to include the first three items on page 14, ending with the application of the Pennsylvania American Water Company.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
It is recommended that the commission adopt the proposed order regarding the petition and letter of notification filed by PPL.
Is there a motion to call up the matter for consideration?
So moved.
Is there a second?
Second?
Motion by Commissioner Kennard, second by Vice Chairman Place. Under discussion, any discussion?
Yes, I have a motion on the matter.
Vice Chairman Place.
Thank you. Madam Secretary, I ask that my motion be placed into the record as if I had read it in its entirety. Before the commission is the petition of PPL Electric Utilities Corporation seeking a waiver in order to file a letter of notification in lieu of an application. PPL Electric also filed a lawn pursuant to the commission's transmission line siting regulation. The petition concerns a section of the Siegfried East Palmerton line, two associated transmission line taps, and PPL Electric's plan to rebuild them. The subject section of transmission line is a combination of one double circuit line and two parallel single circuit lines in Lower Towamensing Township, Carbon County. Under the Commission's siting regulations, the company must establish a clear need for the project and demonstrate the proposed solution is an efficient and cost-effective choice relative to other alternatives. The company at this time has not provided sufficient information to meet these criteria. PPL Electric states that rebuilding Siegfried East Palmerton is necessary to modernize the lines to meet all current design and lightning protection standards and to help ensure reliable and continuous service to customers in Lehigh and Carbon counties. PPL Electric further states that an independent field investigation and assessment was conducted by a third party and revealed that the aging Siegfried East Palmerton transmission line facilities are showing signs of significant deterioration. The assessment concluded that the lines are reaching the end of their reliable service life, approximately 70 years, and that replacing the lines rather than refurbishment was the cost-effective solution. PPL Electric further states that the Palmerton tap and Palmerton zinc tap need to be rebuilt to operate at 138 kV standards. PPL Electric states that the lines traverse heavily industrialized areas which have accelerated the corrosion rates of the steel structures and associated hardware on the lines. Specifically, the assessment identified surface corrosion on tower steel with failing coatings and exposed galvanizing causing corrosion to increase an accelerated rate. PPL Electric further states that contamination has accumulated on the surface of the insulators and is reducing their insulating properties. The assessment also identified many of the wood poles as being in a severe condition, resulting from being directly embedded in marsh and wet areas and from woodpecker damage. PPL Electric states that the load brake air brake switches will allow that sectionizing of the transmission system to restore service to customers in instances of sustained outages or maintenance scenarios. Further data requests, however, potentially contradict the assessment of the reliability of this line. First, PPL disclosed that over the last 5 years, this transmission line only had one outage associated with only one customer. Further, the independent field investigation was limited to a statistically insignificant sample size. The sample set selected for independent field investigation included two types of samples. One, structures that PPL selected known to have had historical maintenance issues that were previously addressed or that were critical structures, for example, road crossings. And two, a random sample that the assessor, DGA, selected from the remainder of the line. Of the 8 sample structures selected, 6 of them were selected by PPL and 2 of them were selected by DGA. Such a small sampling of mostly non-random facilities does not present adequate information as to the state of the facilities. Further, the almost perfect performance of the facilities appears to contradict PPL's assessment of reliability. Lastly, PPL acknowledges that the impact on Katy, Sadie, and Safety is negligible. As to examination of available alternatives, PPL asserts that replacing the lines rather than refurbishment was the cost-effective solution. Data requests revealed that operation and maintenance of the line range from $23,000 to $300,000 per year. PPL also provided a lower cost estimate of $15.9 million for the complete rehabilitation of the line. PPL fails to provide any analysis as to the cost of the alternative solutions, the complete rehabilitation of the line, or the current O&M costs of the existing system relative to the proposed new $23.6 million system. While replacement of the system may be needed at some point, PPL did not provide the necessary support to justify complete replacement at this time. Based on the discussion above, I recommend denial, without prejudice, of the proposed lawn application as it stands. While the Commission's regulations limit PPL's recourse upon denial of a lawn application to filing a full siting application, I am willing to waive that requirement and allow the company some flexibility in determining whether its best course of action is to submit a revised lawn or file a full siting application, should the company seek further approval of the proposed project. PPL's new filing should provide additional support that the project is an optimal solution to maintain reliability on its transmission and distribution system in a cost-effective manner. Therefore, I move that 1. The letter of notification of PPL Electric Utilities Corporation for approval to rebuild approximately 6.9 miles of existing 138/69 kV transmission line in Washington Township, Lehigh County, and the Borough of Palmerton and Lower Townmincing and East Penn Townships, Carbon County, Pennsylvania, be denied without prejudice. 2, that PPL Electric Corporation comply with the Commission's regulations to file an application or file a new lawn consistent with the direction of this order. 3, the Commission's Bureau of Technical Utility Services prepare an order and opinion consistent with this motion. 4, that upon completion of ordering paragraph 2, this proceeding at docket A 2018-3001477 be closed. Thank you.
You have heard the motion of Vice Chairman Place. Is there a second?
Second.
Second by Commissioner Sweet. Any discussion on the motion?
Yes, Madam Chairman. Commissioner Coleman and I have a joint statement that we ask be read in its entirety into the record as if read in its entirety. And I'll summarize it. Before the Commission is a petition, a waiver, and letter of notification of PPL. In this petition, PPL asks for two things. The first is a waiver of the requirement that the right-of-way be maintained in its entirety. The second request is that the LON be approved. The waiver is needed because PPL has proposed at the urging of a landowner that the right-of-way be moved by 0.3 miles of the along a entirety of a 6.9 mile transmission line project. The Nature Center requested that the right-of-way be moved. The adjacent landowners did not disapprove, did not object, and therefore granting of the waiver would be appropriate. In addition to the waiver, PPL seeks LON approval for the proposed transmission line project. The evidence of record demonstrates to Commissioner Cohen and myself that the proposed project is necessary to, quote, meet present and future demands for service, which is the sole need standard established under our regulations. The LON process was designed to create an efficient and abbreviated process for cases such as this one and to avoid delay of important projects and ultimately to ensure adequate, reasonable, and reliable service. The motion today, however, creates additional requirements outside of that enumerated in our regulations. For example, the motion requires the proposed project is the most efficient and cost-effective choice relative to other alternatives. That standard appears nowhere in our regulations. If there is a desire, which there appears to be, to change the criteria that the Commission uses when evaluating LON applications for transmission line projects, the Commission should forthrightly engage in a rulemaking process to make these changes, use the rulemaking process to ensure that the industry and all interested stakeholders are provided adequate opportunity to participate and anticipate potential modifications in our LON process, and that it is a mistake to reform the process through a series of individual case resolutions. Thank you.
Thank you, Commissioner Kennard. Any further discussion? Hearing none. On the motion, all those in favor say aye.
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 Any opposed?
Opposed?
The motion passes 3-2, noting the dissent of Commissioner Kennard and Commissioner Coleman on the matter as amended. If there's no objection, we will take the previous roll call. Seeing no objection, the matter as amended passes 3-2, noting the dissent of Commissioner Kennard and Commissioner Coleman.
Turning to page 15, it is recommended in an omnibus motion that the Commission adopt all of the items on page 15, beginning with the application of Integrity Communications and continuing to include all of the items on page 16 and all of the items on page 17 and the single item on page 18, the Securities Certificates of Citizens Electric et al.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second?
Motion by Commissioner Kennard, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 19 and matters presented by Chief Counsel Panque and the Law Bureau. It is recommended that the Commission adopt the proposed order regarding the implementation of Section 1329.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Vice Chairman Place. Any discussion?
Madam Chairman, I have a statement that I ask to be read into the record, entered into the record as if read in its entirety. Basically, what we're doing today is supplementing the tentative implementation order that we initially entered upon the passage of this new section of the Public Utility Code. The applications that we have considered since passage of the addition of Section 1329 to the code has indicated that our procedures and guidelines could be improved. And to this end, the Commission staff and affected stakeholders have met to discuss improving our processes. That has been successfully culminated in the order that we enter today. We look forward to the comments of the parties, and I wish to thank the water companies, I&E, OCA, OSBA, and our Commission staff, particularly the Law Bureau, for their diligent collaboration and hard work to come to the compromises represented in the order we enter today. Thank you.
Thank you, Commissioner Kennard. Any further comments?
Madam Chair,
Commissioner Coleman, Commissioner Sweet.
if I could, I just want to indicate my agreement with everything that Commissioner Kennard just said. These 1329 cases and situations represented some hard decisions, and there were some real need for some procedural reforms, and our staff stepped up to the plate, particularly led by our chief counsel, and conducted what were some difficult, at times, negotiations with the affected stakeholders, and have come to what I think is a very beneficial conclusion.
Thank you, Commissioner Sweet. Any further comments or discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
It is recommended that the Commission adopt the proposed order regarding the petition filed by PennDOT.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Sweet, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
And finally, on page 19, it is recommended that the commission adopt the proposed order regarding the petition of the Retail Energy Supply Association.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Kennard. Any discussion?
Yes, I have a statement on the matter.
Vice Chairman Place.
Thank you. Madam Secretary, I ask that my statement be placed into the record as if I had read it in its entirety. Before the Commission today is a tentative order regarding the petition of the Retail Energy Supply Association to simplify their financial security 5% renewal process. On June 6, 2017, RISA petitioned the Commission to make changes to reduce processing time and effort for both the Commission and the EGS community. The petition proposes a simplified filing process using a less burdensome compliance filing rather than a formal petition process, in addition to more streamlined documentation submission requirements. Commission staff recommends a partial approval of RISA's petition, which makes strides towards improving processes and reducing the burden for annual security reduction renewals. While this tentative order does not address all of the issues RISA raised and the relief requested, I believe this is a step in the right direction, and given the vintage of this petition, believes it's important to set this motion, the changes in this motion approved therein. That being said, the Commission should and will continue to look for process improvement and continue to examine tools and options to aid in fulfilling our oversight whilst improving customer service and coordination with both the public and members of the regulated community. Thank you.
Thank you, Vice Chairman Place. Any further comments or discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 20, it is recommended in an omnibus motion that the Commission adopt all three items on page 20, beginning with the reconsideration of Pike County's petition and ending with the petition of the Pico Energy Company.
Is there a motion to adopt staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Sweet. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
Turning to page 21, and matters presented by Chief ALJ Rainey in the Office of Administrative Law Judge, it is recommended that the Commission adopt ALJ Gould's initial decision regarding the application of premium taxi.
Is there a motion to call up the matter for consideration?
So moved?
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Coleman. Any discussion?
I have a motion, Madam Chair.
Commissioner Sweet.
Thank you. I ask that my motion be placed upon the record as if I'd read it in its entirety. Before us is the initial decision of Administrative Law Judge Marta Gould, which grants the motion to dismiss of the protesting carriers to the application for taxi authority filed by Premium Taxi LLC, following the applicant's failure to attend the second evidentiary hearing. Normally, failure to attend an evidentiary hearing will result in the denial of any further rights. But in this case, there are extenuating circumstances which require the Commission to reset the procedural clock and give the applicant another opportunity to move forward with this application. Following a series of what I would characterize as procedural snafus by both the applicant and the Commission staff, applicant's ability to move forward in this docket was blocked. By this motion, I give the applicant another opportunity to pursue Commission approval of its enlarged territory. In order to do that, applicant will be given 60 days from the date of entry of the Commission's order to file an amended application which clearly states the territory it seeks. Should the applicant not file an amended application in that 60-day period, the docket will be closed. Therefore, I move that the initial decision of Administrative Law Judge Marta Gould is vacated. Secondly, Premium Taxi LLC may file an amended application at this docket within 60 days of the entry of this order. 3, should Premium Taxi file an amended application within 60 days of the entry date of the Commission's order, that it be assigned to the Commission's Bureau of Technical Utility Services for routine processing, including but not limited to contacting the applicant to ensure that the correct authority sought is stated in the caption, and the subsequent publication of notice of the amended application in the Pennsylvania Bulletin and referral to the Office of Administrative Law Judge should there be any protests filed. 4, failure of Premium Taxi LLC to file an amended application within 60 days of the entry date of the Commission's order will result in the closing of this docket. 5, the Office of Special Assistance is to prepare an appropriate order consistent with this motion. Thank you.
You have heard the motion of Commissioner Sweet. Is there a second?
Second?
Second by Vice Chairman Place. Any discussion on the motion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. On the matter as amended, if there's no objection, we'll take the previous roll call. Seeing no objection, the matter as amended passes 5-0.
It is recommended that the Commission adopt ALJ Pell's initial decision in the complaint of Calvin Hayes versus the Philadelphia Gas Works.
Is there a motion to call up the matter for consideration?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Coleman. Any discussion?
Madam Chair, for the last time in the morning, I have a motion.
Commissioner Sweet.
Thank you. And I ask that my motion be placed upon the record as if I'd read it in its entirety. This case comes to us upon review of the initial decision of Deputy Chief Administrative Law Judge Christopher Pell, ALJ, which denies the complaint brought forth by the complainant Calvin Hayes for failure to sustain his burden of demonstrating allegations that there were incorrect charges on his bill, as well as his request to receive a second commission-issued payment arrangement. I agree with the ALJ's decision to deny the complainant's allegations regarding incorrect billing charges. However, I believe Mr. Hayes' request to receive a second commission-issued payment arrangement warrants reconsideration based on the evidence provided on the record. Regarding the complainant's request for second commission-issued payment arrangement, Chapter 14 of the Public Utility Code provides, and I quote, "Absent a change in income, the Commission shall not establish or order a public utility to establish a second or subsequent payment arrangement if a customer is defaulted on a previous payment arrangement," close quote. Yet, Chapter 14 also allows for a 6-month extension of a payment arrangement in default if the default was the result of a, and I quote, "significant change in circumstance," close quote. One of the provisions included in this subsection of Chapter 14 is if there is an increase in the customer's number of dependents in the household. The complainant testified that in October 2017, his then one-person household's gross monthly income was $1,075 when the Bureau of Consumer Services, BCS, granted him the payment arrangement. However, after the October 2017 determination from BCS, Mr. Hayes' son moved in with him. Given the change in household size, the ALJ questioned whether the complainant's gross monthly household income changed as a result, to which Hayes explained that his monthly household income, solely comprised of his supplemental Social Security benefits, had increased to $1,093. In this situation, the ALJ noted the complainant's income had increased, not decreased, and therefore does not meet the standards as he perceived them defined in Chapter 14, subsection D. While I cannot disagree with the ALJ's determination that there is a minor change of income, I believe that the increased number of dependents in Mr. Hayes' household should not be overlooked, as this piece of information meets the, quote, "significant change in circumstances," close quote, criteria, as defined by the statute, and which would trigger the allowance of a 6-month extension of Mr. Hayes' commission-issued payment arrangement. Therefore, I move that the initial decision of the administrative law judge in this case is affirmed in part and denied in part, is confirmed in part and reversed in part, consistent with this motion. Secondly, that per section 1405E of the Public Utility Code, the complainant is granted a 6-month extension of his initial payment arrangement. And thirdly, that the Office of Special Assistance prepare an order consistent with this motion. Thank you.
You have heard the motion of Commissioner Sweet. Is there a second?
Second.
Second by Commissioner Kennard. Any discussion on the motion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. The matter as amended. If there's no objection, take the previous roll call. Seeing no objection, the matter as amended passes 5-0.
It is recommended that the commission adopt ALJ's, Vero, and Gould's recommended decision approving the settlement in the application of Aqua Pennsylvania wastewater.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second?
Motion by Commissioner Kennard, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The matter passes 5-0.
Madam Chairman, that concludes the regular agenda. Turning now to the carry-in agenda. At the top of page 1, it is recommended by the Office of Special Assistance that the commission adopt the proposed opinion and order granting the petitions pending review of and consideration on the merits of the First Energy companies.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second? Motion by Commissioner Kennard, second by Commissioner Coleman. Any discussion? Hearing none, all those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
It is recommended that the commission adopt in an omnibus motion both opinions and orders regarding the Peoples Gas companies at the bottom of page 1 and at the top of page 2 of the carry-in agenda.
Is there a motion to adopt staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Kennard. Any discussion?
Yes, I have a statement on the matter.
Vice Chairman Place.
Thank you. Madam Secretary, I ask that my statement be placed into the record as if I had read it in its entirety. Before us is the purchased gas cost filings, as well as the joint petition for partial settlement of Peoples Gas Company LLC, Peoples Natural Gas Company LLC, acting on behalf of its Peoples Division and its Equitable Division. The parties in this case reached consensus on all issues except whether to approve a fuel retention charge on conventional gas producers connected directly to the company's gathering and distribution systems. I support the ALJ's recommended decision to approve this charge, believing that the companies carried their burden of proof to initiate this charge. Most importantly, I believe that the producers are the main beneficiaries of these low-pressure systems, especially in areas where delivery customer services are scarce. Going forward, however, I remain open to further arrangements. I'll start that again. Going forward, however, I remain open to further arguments as to where on the system such retention charges should be imposed and the amount of that charge. Specifically, in future 1307F filings or in base rate cases, greater detail should be provided regarding the following issues. 1. The full average unit cost of natural gas supply from conventional suppliers interconnected directly with the gathering and distribution systems of the companies relative to the full cost of supply at the city gate delivered from interstate pipelines to the companies. 2. The cost of service net of distribution system customer revenues as well as production volumes on these gathering systems. 3. Administrative costs related to implementation of separate retention fuel charges for gathering and distribution versus combined billing as is done today in Equitable. And 4, continued collection of gathering system and distribution system lost data. Information on the above issues will assist the Commission in determining the true beneficiaries of the company's lower pressure systems and the value of that cost support. Thank you.
Thank you very much, Vice Chairman Place. Any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? Motion passes 5-0.
Continuing on page 2 of the carry-in, in an omnibus motion, it is recommended by the Bureau of Technical Utility Services that the Commission adopt both of the items remaining on page 2.
Is there a motion to adopt staff recommendations?
So moved.
Motion by Commissioner Kennard, second by Commissioner Sweet. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 3 of the carry-in, it is recommended by the Office of Administrative Law Judge that the Commission adopt ALJ Myers and ALJ Cheskis' recommended decision approving the joint petition for settlement without modification of the UGI utilities.
Is there a motion to call up the matter for consideration?
So moved.
Is there a second?
Second?
Motion by Commissioner Kennard, second by Vice Chairman Place. I do have a motion under discussion, so I will turn over the gavel to Vice Chairman Place to preside.
Thank you, Chairman. I'd like to recognize Chairman Brown for the purposes of her motion. Chairman Brown.
I ask that my motion be spread upon the record in its entirety, and I actually will read the entire thing. Before the Commission is the joint petition for settlement of the merger application filed by UGI Utilities, Inc., UGI Penn Natural Gas, Inc., and UGI Central Penn Gas, Inc. I believe it is necessary to ensure that the Commission can continue to appropriately monitor each of the three UGI district earnings. The necessity originates from the requirements under Section 1358B3 of the Public Utility Code, which requires that a utilities distribution system improvement charge be reset to zero if the utility's financial reporting indicates it is over-earning. Therefore, notwithstanding any provision in this joint statement, it should be clarified that as a condition to approving the joint settlement, UGI must continue to file quarterly and annual earnings reports for each of the three UGI natural gas entities until further notice by the Commission. I believe such clarification is necessary because upon approval of the settlement, each UGI district will continue to have separately tariffed DISC and distribution charges. The requirement to file quarterly and annual earnings reports for each of the three UGI natural gas entities may become unnecessary in the future when the three districts' rates become uniform. Since this requirement may be inconsistent with paragraph 8 of the joint settlement related to Chapter 71 financial earnings reporting requirements, I propose that the parties be given 5 days from the Commission's action today to submit any comments concerning this requirement. If no adverse comments are filed within 5 days, the joint settlement shall be approved without further action by the Commission as clarified by this motion on or before September 28, 2018. If adverse comments are filed, the Commission will issue a forthcoming opinion and order addressing the merits of the comments and the disposition of the joint settlement. Therefore, I move that, 1, the joint petition for settlement be approved on the condition that UGI must continue to file quarterly and annual earnings reports for each of the three UGI natural gas entities until further notice by the Commission consistent with this motion, and 2, the Office of Special Assistance draft an appropriate opinion and order consistent with this motion.
Having heard the motion, is there a second? Second. Seconded by Commissioner Sweet. Any discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed?
Mr. Vice Chairman, I would vote to approve the unanimous settlement without modification and therefore vote no.
Hearing that, the motion carries 4-1, noting the dissent of Commissioner Kennard. Any further discussion on the matter as amended? Hearing none, is there any objection to recording the vote on the motion as amended? The motion carries, noting the 4-1, noting the dissent of Commissioner Kennard.
And finally, on page 3 of the carry-in, there is your motion, Madam Chairman.
Thank you. Is there a motion to bring up the matter? Moved by Commissioner Sweet. Is there a second?
Second?
I recognize Chairman Brown for the purposes of promotion.
Thank you. And I ask that my motion be entered into the record in its entirety. Administrative agencies like the PUC are required to provide due process to the parties appearing before them, and that due process requirement is satisfied when the parties are provided notice and the opportunity to appear and be heard. When a formal complaint is filed with the commission, a complainant is sent instructions which address, among other things, requests for continuance, subpoena procedures, attorney representation, and other procedural requirements, and the commission's policy encouraging settlements. Besides the instructions, those individuals who do choose to prosecute their complaints may even be served discovery by the utility, all of which may be confusing for some, and failure to understand these can result in having the case dismissed. The system of notifications, forms, and information either sent to or available to consumers is thorough and detailed, and that information appears in a format that is meant to be easily understood. But in a world where missed appointments are easily rescheduled, there are bound to be misunderstandings regarding when a missed hearing results in a dismissal of a case and when it can be rescheduled. In recent months, the commission has grappled with just that issue, resulting in possibly inconsistent decisions. There is no doubt that the commission staff works hard to ensure that each and every complainant receives the due process required by law. But as time goes by and circumstances change, even the soundest of policies should be reevaluated with an eye towards improvement. I fully understand and appreciate the efforts of everyone involved in conducting an evidentiary hearing, whether it's done telephonically or in person. In many instances, utility companies have to secure witnesses, prepare exhibits from company records, and expend financial resources to prepare for a hearing where the complainant does not show. These financial resources are ultimately borne by other customers. During my tenure here at the Public Utility Commission, I have expressed concern over the Commission's practice of dismissing pro se complainants with prejudice for failure to appear at hearings as being inconsistent with Section 1.2 of our regulation and the Commission's own case precedent regarding due process. My overall concern is not with the dismissal of the matter before the administrative law judge, but the dismissal of cases with prejudice in almost all cases where the pro se complainant does not appear. In my opinion, in cases where there's no reason to suspect that the Commission's administrative process is being abused, dismissing without prejudice protects the complainant's right to due process while respecting the Commission's administrative process. That is why I am proposing the formation of an internal working group to review and evaluate the internal processes from the first call received from a customer to the handling of exceptions to a formal initial decision with an eye towards clarification and simplification of the process. The collaborative should include representatives from the Office of Administrative Law Judge, the Office of Special Assistants, the Bureau of Consumer Services, and the Secretary's Bureau, and be spearheaded by the Law Bureau. At the end of the process, there should be a recommendation prepared by the Law Bureau which addresses the following at a minimum and may include other issues as necessary. Information conveyed to customers during and following a BCS investigation and informal determination. Process and forms used in the appeal of an informal determination with formal complaints. Forms used in the formal complaint process. Available literature explaining the formal complaint process. Types of hearings available. Under what circumstances a formal hearing may be continued. When a formal hearing can be rescheduled if the customer fails to attend a scheduled hearing. When a case should be remanded for rescheduling after a hearing is missed. When it is appropriate for a utility to serve discovery on a pro se complainant. I recognize that these issues have been reviewed before and that the outcome of this project may be to find that we as a commission are doing everything correct. But I also know that even the best of processes can be improved. I am hopeful that a fresh review of our policy will come up with a way to better serve the consumers of this Commonwealth by reducing the number of hearings where the complainants fail to show. If the staff recommendations result in the formulation of a policy statement, regulation, or amendments that address one or more of these issues, then the recommendation should be presented at a regularly scheduled public meeting report, as a regularly scheduled public meeting report as a Law Bureau agenda item. Therefore, I move that, 1, the Law Bureau form a working group that includes members designated by the directors of the Office of Administrative Law Judge, the Office of Special Assistants, the Bureau of Consumer Services, and the Secretary's Bureau. 2, the working group is tasked to collaboratively review the processes, forms relating to pro se complainants, both informal and formal. 3, the working group produce a report and/or recommendation regarding improving commission processes and forms related to pro se complainants, both formal and informal, no later than 9 months from the date of this motion. And 4, the Office of Special Assistants prepare an opinion and order consistent with this motion.
Thank you. The record should note that the motion to bring up the matter was seconded by Commissioner Coleman. I failed to make that note. Having heard the motion, is there a second?
Second.
Seconded by Commissioner Kennard. Any discussion of the matter? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? The motion carries 5-0. Gavel is yours, Chairman.
Thank you very much.
Madam Chairman and Commissioners, that concludes all of today's agenda before the Commission.
Thank you. Before we adjourn the meeting, there are a couple items that we would like to bring to your recognition. First being the National Preparedness Month. Each September, we recognize National Preparedness Month as we recognize and remind Pennsylvanians to be prepared for disasters and emergencies in their homes, businesses, and their communities. As we've seen just recently with the devastating hurricane in the southeast, every second counts in an emergency situation, and that's why it's crucial to already have a plan. Homeowners, families, communities, and businesses should learn more about preparing for disasters and reducing risk to health and the environment before the emergency. Take time to learn life-saving skills such as CPR and first aid. Check your insurance policies and coverage for the hazards you may face, such as flood, earthquakes, and tornadoes. Make sure to consider the costs associated with disasters and save for an emergency. Also, know how to take practical safety steps like shutting off water and gas. Disaster happens, prepare now, and learn how. That's a great segue also into the recognition of the month of October, which is Cybersecurity Awareness Month. Let me first note that we have taken cybersecurity very seriously here in the Commission, and in doing so, we are pleased to announce the appointment of Michael Holko as the Director of the newly formed Office of Cybersecurity Compliance and Oversight. We welcome him to the PUC team as he joins us in this most crucial position. The creation of our new Office of Cybersecurity Compliance and Oversight is the next important step in the Commission's continued efforts to protect Pennsylvania utility customers from experiencing disruption of utility services and other vital systems and services that we depend on. Michael's experience includes positions at the state's Office of Administration's Bureau of Personnel, the state's Office of the Budget, the Pennsylvania Justice Network, and most recently as the program manager at the state office of the Office of Administration, Office for Information Technology. He received his bachelor's and master's degree from Slippery Rock University and resides here in Harrisburg. As the director of the Office of Cybersecurity Compliance and Oversight, he will advise the executive director and commissioners on policy issues and procedural improvements involving cybersecurity oversight, functions of regulated utilities, draft proposed cyber-related regulations, and oversee the preparation of orders, rulemakings, policy statements, secretarial letters, and memoranda related to cybersecurity policies and procedures of those regulated utilities. As we prepare for Cybersecurity Awareness Month in October, the PUC continues working with utilities, state agencies, as the Pennsylvania Emergency Management Agency and the Governor's Office of Homeland Security, emergency responders, and other organizations to better prepare for cyber and physical attacks, strengthen critical systems, share information about current and future threats, and ensure that essential services such as resilient are possible. Essential services are resilient as possible. It is equally important for consumers to review Pennsylvania's online cybersecurity guide for tips to prevent identity theft, protect passwords, keep children safe online, and secure mobile devices. Lastly, I would refer utilities to the cybersecurity best practices for the small and medium Pennsylvania utility guide published by the PUC and available on our website. So our congratulations to Michael Holko on his appointment here at the commission. Thank you. Also want to turn the microphone over to Commissioner Kennard for an announcement.
Thank you, Chairman Brown. Each September, we recognize Lifeline Awareness Week that keeps nearly 500,000 low-income Pennsylvanians connected to the telecommunications network through the Lifeline discount program. I don't know how cybersecurity got a week and Lifeline, we got a month. Lifeline only gets a week and mothers get a day. So maybe we ought to investigate that. Lifeline is intended to make communications, voice, and broadband more affordable and more accessible to low-income households, helping them stay connected to information about jobs, family, healthcare, schools, and emergency services, to mention a few. Lifeline program is a government benefit program that provides eligible low-income customers with a discount of $9.25 on their monthly service for voice, internet, or a combination of the two. A customer qualifies for Lifeline if they are at or below 135% of poverty or participate in specific federal programs. Customers that may be eligible should contact and are encouraged by us to contact their current telephone or internet service provider for more information. Thank you.
Thank you very much, Commissioner Kennard. There's no other business to come before us. If there's no objection, seeing no objection, we are adjourned.